religion specific. So say for example, the Hindu Marriage Act of 1955 would govern marriages of Hindus only and would not be applicable to Muslims or Christians in the country. Similarly, there are different provisions that govern Muslims in India or Christians in India and the like. Supplementary to this, there are also secular legislations. For example, the Guardian and Wards Act. It's important to note here that Section 6 of the Guardian and Wards Act provides that the mother is the primary caregiver of the child and should have natural custody of the child until the child is 5 years old. However, it also provides for the father being the guardian before the mother for children above the age of 5. And I will come back to why this is relevant in a moment. Another aspect that is important and crucial to note here is that since India is not a party to the Hague Convention, things like interparental child abduction are not recognized. The ethos behind this is that the Indian courts and the Indian legislature does not believe that parents can abduct their children because parents are natural guardians. So how could someone who provides care, how can someone who safeguards rights of their children abduct them? And that is where a lot of complications factor in. And while this approach is idealistic, in these conflicts, the rights of children get severely adversely affected. And that is extremely important here. So because there is no statutory recognition of the problem, it also means that there is no statutory remedy that can be provided to children or parents involved in situations like this. However, with the ratification of the United Nations Convention on the Rights of Child, there are enabling provisions that have been enacted in domestic legislation, which means that now, ever since 2018, as late as 2018, judges and courts in India have moved towards a child-centric approach. They have started factoring in welfare of the child, giving the child a voice. And it is important to note here that the social worker system in India is absent. So there is perhaps nobody to advocate for the child but the child themselves. And it is in that context that the rights of parents have to be balanced with the rights of child. So the right of the mother has to be balanced against the right of the father, and also at the same time, both these rights have to be balanced against the rights of children. Now the first issue that plagues a lot of interparental problems, inter-country parental problems, is that of jurisdiction. And here is where Section 6 becomes important, which I was referring to earlier. Now because Section 6 says that the mother is the primary caretaker and caregiver of children under the age of 5, would that mean that the jurisdiction of the child would be determined by the jurisdiction of the mother? Perhaps not, because courts have also interpreted, especially in Jasmeet Kaur versus Navteej Singh, that the jurisdiction of the forum that is fit to decide cases involving children would be that of ordinary residence. So now, ordinary residence is understood as where the child would reside had this conflict not taken place. And this perhaps may be different from the jurisdiction of the mother. So here is a conflict of laws, and here is where a dilemma sets in. Now, there are also two more approaches that Indian courts have taken while determining jurisdiction. The first one is that of first trek, which was jurisprudentially evolved in the case of Nithya Anand Raghavan versus State of Delhi, which is where the court said that the jurisdiction of the forum that is approached first. So say for example in a situation where the father and the mother have lived in the United Kingdom but are of Indian origin and the child is born in India and the father has approached the courts in UK, that jurisdiction would supersede jurisdiction in India because that was the forum that was approached before the Indian forum. But the other approach that courts have also paid heed to is that of intimate contact and closest concern. Now this is an approach that was followed in Prateek Gupta versus Shilpi Gupta. Now perhaps these are also contradictory approaches because the point of closer contact may not be the forum that is approached first. So if a child like in Nithya's case, has grown up in India, has lived a majority of their lives in India, closer contact would then be established not with the UK but with Indian jurisdiction. Now another matter of concern is that that rarely do Indian courts take cognizance of the validity of foreign judgments. Comity of courts perhaps is not as evolved a principle as it is elsewhere. So what does end up happening is that even while there are foreign judgments that have been delivered pertaining to the same matter, there is fresh adjudication on those very matters by Indian courts. So say if welfare of a child has been determined by a foreign court, the Indian court will go ahead and perhaps adjudicate and look into evidence and rehear matters of best interest of children in the Indian court as well. Now this leads to a problem of perhaps double adjudication, which can possibly also contradict which can also be possibly contradictory. And here is where perhaps the solution or the way to a solution would be to introduce mirroring orders. And while India is not party to the Hague Convention, which does provide for a framework like this, there are very many procedural barriers to it. However, recently, as late as 2018, Indian courts have become amenable to perhaps introducing the concept of mirroring of orders, which would solve very many problems. It would mean that Indian women, vulnerable women, would not have to experience the wrath of complicated, expensive litigation in unfamiliar environments, and perhaps judgments that have been passed by foreign courts can be replicated in their home states, or judgments that have been passed in their home states can be replicated in their areas of ordinary residence. So one thought that I would like to leave you with before I hand over the mic to my co-speaker is understand or think about whether the mirror order jurisprudence can be an alternative or can be a replacement for India signing the Hague Convention. Maybe the answer only lies in how courts continue to interpret it and whether or not it becomes an evolved jurisprudential phenomenon.
First of all, Henry, thank you for the wonderful introduction. Friends, welcome to the last speaker's patience, which I'm testing for the graveyard session. It's end of the day. The topic is very varied. Yes, Henry, the Hague Convention still remains the elusive albatross, which I have not yet been able to secure in 35 years. I have seen Mr. Han Van Loon, William Duncan, my friend Philip Loddy sitting at the back. So I do not know when and where. But I, through innovation or crafting as a lawyer, have now tried different means and methods, which I will tell you and share with you in a recent matter which I have caught, of how possibly we can move forward through the process of the courts. Because judicial innovation or judicial legislation, as we call it in India, or practice directions is probably the way forward. Because the will of the government to sign the convention is still not apparent. I was on the Hague Committee with the government, constituted by the government of India, with 6 judges and 6 government officers. But I don't think we are still near it. Anyway, friends, we are a unique jurisdiction. We are 3.28 million square kilometers, 30 states, 7 union territories, 1.2 billion Indians, 32 million living in 208 countries. So we are a world apart, honestly. But we are miles away from the Hague Convention on Child Abduction 1980. We still fall back on the jurisdiction of a 127-year-old law, the Guardian and Wards Act 1890, for determining exclusive guardianship or custody, where a parent removing a child often seeks umbrage in a domestic court for seeking guardianship orders or exclusive custody orders by wanting the other parent to be excluded. But then, when you remove a child and you bring a child from a foreign jurisdiction, to invoke the jurisdiction of the guardian judge, you must satisfy the court that the child ordinarily resides within the jurisdiction of the guardian judge. I am normally opposing such petitions, So I move in a preliminary objection application saying the child lives in the US, the child is born in the US, the child is a foreign national. Ordinary resident means not where the child is residing on the date of the filing of the petition or where the mother is brought up. And I invariably succeed. So in this, but then the question is, what is the remedy available then to the parent living abroad who is armed with an order which probably Henry has helped him to get, say from UK, by which there is an order that the child has to be returned to UK. So I cannot go to the guardian judge because the child doesn't live here. And the Supreme Court says that this is Ruchi Maju, 2011 Supreme Court, a court that has no jurisdiction to entertain a petition for custody cannot pass any order or issue any direction for a return of the child from where he was removed, no matter that such removal was found to be in violation of an order issued by a court in that country. The party aggrieved by such removal may seek other legal remedies open to it, but no redress to such a party will be permissible before the court who finds that it has no jurisdiction to entertain the proceedings. So the spouse challenging the jurisdiction of the guardian judge cannot go to the guardian judge because the child does not ordinarily reside in that territorial limit within India. So where do we go? Our first speaker introduced us to a jurisdiction, the parents betray jurisdiction. Now that is a remedy, Henry, we use every day. I use it day in, day out. Under the Constitution of India, we have a prerogative writ. There are 6 different kinds of writs, but the writ which concerns us is the writ of habeas corpus. It is an extraordinary remedy invoked under the Constitution of India by invoking the jurisdiction of the High Court under Article 226, if the child is within the jurisdiction of the High Court, or you can hit the Supreme Court of India straight under Article 32. Now, the logic, the basis of invoking the extraordinary remedy is dehors residence, because we inherit this writ from English and American law, because the court says the basis of the issuance of a writ of habeas corpus in a child custody is not a case of illegal detention, but the primary purpose is to furnish a means by which the court, in the exercise of its judicial discretion, may determine what is best for the welfare of the child, and the decision is reached by a consideration of the equities involved in the welfare of the child, against which the legal rights of no one, including the parents, are allowed to militate. I was quite surprised to see the background which the first speaker described of this writ. But regardless, it does a wonderful job. Because minus the ordinarily resides bar, this is the only remedy in the absence of the 1980 convention to a parent, agreed parent, whose child has been surreptitiously removed across borders. And mind you, we have 32 million of them in 208 countries. So probably there is an abduction every day in some part of the world to India or out of India. It's that frequent. So this is the remedy scenario. Now, as Aastha told you, because child removal is not an offence, so there is no remedy statutorily. So you cannot invoke any other remedy under civil or criminal law, because if you were to go to a court, or if you were to go to the police, or you were to go to an executive authority, you would say, what's wrong? If the natural guardian is having the child, what's wrong? If you have a foreign court order, test it out. So the law on the subject which has evolved is law made by the Supreme Court of India. So we start with 1984, Surinder Kaur, Elizabeth Dinshaw in 1987, where the Supreme Court in those times used to exercise summary jurisdiction. They would say, Committee of Courts, jurisdiction of closest contact, child should be summarily returned to the jurisdiction of the foreign court from where the child was removed. Then came problems which Indian women started expressing about domestic violence, about lack of finances, about hostile conditions, about being subjugated, etc., etc. So in 1998 in Dhanwanti Joshi and in 2003 in Sarita Sharma, the Supreme Court said domestic courts will rule, foreign court orders will be only one consideration. Then again there is a flip-flop. Ravi Chandran 2010, Shilpa Agarwal 2010, then Arthi Bandi 2013. The Supreme Court said if foreign courts had passed an order and a spouse or a mother or a father was singularly responsible for the removal of the child, and the child had initially lived in the years in a foreign jurisdiction, the country which has the closest contact will determine the dispute and the child should go back. So there was some stability for some time. Then Justice Madan Lukur, a very celebrated judge who's not on the bench anymore, he laid down practice directions in Surya Vadanan in 2015. So a 5-decade chain of case law got crystallized. And I'll quickly run through the salient points. They said we have evolved a multi-jurisdictional child custody dispute principle, and which are Committee of Court should be respected, principle of first strike, that is, the court first sees in the matter will have the privilege of jurisdiction in adjudicating the best of the child. So theory of first strike was coined. Committee of Court should not be abandoned except for compelling reasons. Interlocutory orders of foreign courts should be respected. Elaborate or summary inquiry must be held where there is a pre-existing order, but it must be based on reasons that are not ordered in the routine. Nature and effect of foreign court order, reasons for repatriation, etc., will be considered. So all goes well till 2017. So in 2017, we move backwards. So we have 3 decisions in 2017. The first one is Nithya Anand Raghavan, 2017. Now, Nithya Anand Raghavan in 2017, the Supreme Court demolishes the theory of first strike. 1. 2. It says Committee of Courts has no place in child custody disputes. Child removal cases should be decided on the merits, on the welfare of the child principle. Foreign court order will be one consideration. Courts are free to decline the relief of the return of the child within its jurisdiction. Courts may conduct summary or elaborate inquiry. High Court can exercise parents' peculiar jurisdiction. Remedy of habeas corpus should not be used for enforcement of foreign court directions. Substantive remedies should be used. High Court can examine the return of the minor child without being fixated. They started using the word fixated. First strike is abolished. Summary return should be exercised only in rare cases. Now, according to me, this judgment created a dilemma. If I was not allowed to use the habeas corpus remedy, and I could not use the Guardian and Wards Act because the child did not reside there, what is the other remedy that I can invoke? As an academic and as a practicing lawyer who travels all over India doing these cases, I criticized the judgment. But things did not change. There was another judgment in Prateek Gupta following this. First strike overruled. Doctrine of intimate and closest contact was the only one saved. In limited means where the issue of repatriation is clearly founded on the predominant imperative of the overall well-being of the child. Then in the process of adjudication of repatriation, court can elect to adopt a summary inquiry or a detailed inquiry on the principle of the welfare of the child. Doctrine of intimate and closest contact has only persuasive relevance. There is no forum convenience in whatship jurisdiction, and ultimately the court said the domestic court shall decide. Now, the window which these two decisions left was the principle of jurisdiction of closest contact. First strike gone, comedy of courts gone. So the doctrine of most intimate contact or closest concern with the child, that is where the child was born, where the child grew up, where the child habitually normally resided, as the basis for the return of the child was the only logic that survived. Now, this led to another decision in Kanika Goyal versus Karan Goyal. That is a decision made in 2018, in which again a mother who had brought a child from the US, violating a prenuptial agreement and violating the custody orders of the father, the Supreme Court ruled that in the divorce petition where the child custody issue was pending, the issue of custody will be decided, child will not go back to the US, and the father can visit the child in India wherever he wishes. The mother can go to the US to contest the proceedings minus the child. It's a very odd situation. Now, I got involved in a matter about end of 2016. This is Jasmeet Kaur versus Nithya Anand. It's a very interesting case. It's a couple of Indian origin who married in the US. They are Sikhs by religion, but both husband and wife are US nationals. They got married in the US in 2006, set up a dental practice. They are both dentists. In 2016, the wife comes to India for the wedding of her brother. She has with her a 5-year-old daughter. The husband also attends the wedding with his parents. They are all supposed to go back on return tickets. She refuses to go back. He goes back to the US, and in June he gets emergency custody orders, ex parte, from a court in Connecticut. He tries to enforce them. As a counterblast, the lady goes to the guardian judge and seeks exclusive ex parte interim custody and also exclusive custody. Fault of draft of petition, no guardianship is claimed. We contest that petition on a preliminary application of jurisdiction. Children not residing, we succeed. Matter goes to the High Court. It tries reconciliation, doesn't work. The High Court, by a detailed judgment, upholds the order of the family court. No jurisdiction. End of matter. Meanwhile, I also enforce the order of the US court in a writ of habeas corpus, the parents betray jurisdiction, and in which case the Delhi High Court, by a judgment of March 2018, this is the judgment, the exact date is 6th of March 2018, directs the mother to go back. But on the 6th of March 2018, the judge hands out to me a list of protections and says, please go back to the US court and mirror my order and get me all these protections in the US order to enable me to send the lady back. On 20th of May 2018, I come back with that order. The lady still refuses to go back and she's gone to the Supreme Court. This is under challenge. Meanwhile, there is another flip-flop. The jurisdiction judgment which I have obtained is challenged by the woman, the wife in the Supreme Court. The Supreme Court overturns that decision, saying jurisdiction could not have been decided on a preliminary application. Trial, go to trial, 6 months. So I go back to the family court, we do a day-to-day hearing, one leg in Delhi, one leg in the place where I live. 6 months we do a trial, we succeed. She challenges that judgment also in the High Court. And now the Supreme Court says, let us see what the family court decides on custody. Now on July 1, a day before I came, the High Court, by a detailed order, going on a child-centered jurisprudence, has dismissed the mother's petition for guardianship on merits. Now I am going to take the whole thing to the Supreme Court. Now what is the way forward? And very quickly, 2-3 minutes now. I am using the UNCRC, which India has signed, and which India has tried to implement and give teeth by a number of legislations. So, rights of the child. A child has a right to nationality. A child has a right to a home. A child has a right to live with both parents. A child is entitled not to be separated from his parents. So, I have sought implementation of these directions in the writ of habeas corpus, and the High Court agreed with me. The Supreme Court, I'll try to see if I can get the implementation of these, the UNCRC and the best interest of the child, and convince the Supreme Court that if I am able to get, as a matter of principle, a mirror order from a foreign court mirroring an Indian High Court order, let's start the return process. We have over 100 children from the US living in India in violation of court orders. And we are a haven of child removal. You come to India, file 6 cases, nothing will happen. So I think the way forward is a mirror order regime by which India starts mirroring, foreign courts start mirroring Indian court orders, the Supreme Court allows this process to start, puts a judicial stamp on it, we get a verdict, that's the way forward. I don't know whether in my lifetime we'll sign the convention or not, but I think through a judicial mechanism we can start rolling. Maybe Philip Lottey's successor will see the fruits of it. Thank you.
Thank you very much indeed, Anil and Aastha Malhotra. And that's merely scratched the surface. But what an authoritative scratching of the surface of the very complicated and sophisticated picture that is the Indian jurisdiction, which for those who think they know it, well, they soon discover that they don't. Couldn't be more authoritative than the Malhotras on matters of Indian laws. Thank you very much. And ladies and gentlemen, what's more, his timing is perfect too. We can't, as I said, have questions. We're right up to 5 o'clock, and this room will be required for a plenary session. But on your behalf, can I thank Alexandra Tribe and Will Tyler, Queen's Counsel, the Honourable Diana Gould Saltman, and Anil and Aastha Malhotra for the wonderful expositions that they've given us, and thank you all very much for attending.
And in token of Henry chairing our session and very kindly filling in a slot which the worthy chair was to fill it, I have presented Henry a copy of our latest book, The Removed Child and the Law in India. Thank you, Henry.